Welcome to Bcast, Benesch's business law videocast series. This is where we discuss the most topical legal and business issues. In this edition, we're going to be talking to Margo Wolf O'Donnell, Vice Chair of Benesch's Labor and Employment Practice Group in Chicago. Today, host Kevin Margolis is going to talk with Margo about preventing claims of discrimination and harassment.
Hello, I'm Kevin Margolis, a partner in Benesch's Real Estate and Environmental Practice Group. And I'm here today with Margo Wolf O'Donnell, Vice Chair of the firm's Labor and Employment Group in Chicago. Today, we are going to discuss preventing claims of discrimination and harassment. Margo, what are the top 3 things an employer should do to prevent claims of discrimination and harassment?
The first and most important action item that a company should take on immediately is to have a written anti-discrimination and anti-harassment policy. And the policy should be compliant with the law, and there also should be evidence that the policy is given to all the employees and that the employees have signed off on the policy. Next, a company needs to have effective investigation procedures in place. They need to specify the people who do the investigation, and they need to be trained on how to gather documents, how to ask questions, and who the witnesses should be. And then lastly, companies should have effective live trainings. And that's what I do a lot of. I come into companies and I do trainings to teach them what discrimination and harassment is and how to handle those claims.
If we do have to terminate an individual as a result of a claim, what are the best practices for handling a termination?
Well, these terminations are often difficult for companies and the people who are doing them. So I always find it's best when companies have 2 people in place at the termination meeting. So then if it comes down to a case later on and there's a he said, she said as to what occurred, the company has 2 people to testify. It's also important that the reason for the termination be clearly articulated. And if you think that there's a claim that could arise, a release should be given to the employee that you're terminating at the time of the termination.
So what are some best practices for drafting enforceable releases?
So releases are a lot trickier than you would think they would be, and it's important for an employment lawyer to look at them before you give it to an employee that you're attempting to terminate or attempting to get a release from. The release should not be overly broad. It should be specific as to the claims that you want to have released. And it also should not state that the employee could never testify again or could never speak to a government or administrative agency again. And if there's an age claim being released, you need to be careful, and there needs to be specific language in place that an attorney will know and can help you with. And I really like these types of action items because they're very proactive things my clients can do to prevent claims, and it also helps employee morale.
Thanks, Margo, for your insights and for joining us today.
Thank you.